Local government autonomy. Supreme Court has restored hope in democracy. NLC. July 11th, 2024. Joseph Ajero, NLC President. National President of NLC, Joseph Ajero. The Nigeria Labour Congress has welcomed the Supreme Court's judgment affirming fiscal autonomy for local government councils across the country. In a statement on Thursday, the NLC President, Joe Ajero, said the apex court's ruling is a restoration of hope in the country's democracy and judiciary. Ajero asserted that the apex court's verdict is both courageous and salubrious and recalled the tortuous journey to the local government's freedom. He said, "It's an epical pronouncement on Thursday, July 11th, 2024, directing that financial allocations be made directly to local governments as well as divesting state governments of the power to remove local government executives is both courageous and salubrious." The Supreme Court, through this landmark judgment, has not only restored our democracy, but possibly hope in democracy. For years we had watched with dismay and discontent the remorseless and mindless erosion of the powers of the local governments and had embarked on a series of national protests as workers. Ajero also commended the Ninth National Assembly, the administration of ex-President Muhammadu Buhari and President Bola Tinubu for their efforts leading to the ruling. He added, "We also note the effort made by the Buhari administration to prise off the stranglehold of governors on local governments. We must also mention the commendable role on this matter by the Ninth Assembly. This statement will not be complete without paying tribute to the Tinubu government for its presence of mind to institute this action at the Supreme Court. We specifically commend the President and the Attorney General of the Federation." Ajero, however, wants the Supreme Court ruling implemented and questions the conduct of local government elections by state electoral commissions. Should SICS be allowed to conduct elections, or should NEC take over, even as they are overburdened and are not exactly the best example? Should there be a regulatory agency or commission with oversight over seats? "We will find the devil in the details through a stakeholder conversation," he said. On Thursday, the Supreme Court declared that it is unconstitutional for state governors to hold funds allocated for local government administrations. The seven-man panel, in the judgment delivered by Justice Emmanuel Ajim, declared that the 774 local government councils in the country should manage their funds themselves. The apex court held that the power of the government is portioned into three arms of government: the federal, the state, and the local government. The court further declared that a state government has no power to appoint a caretaker committee and a local government council is only recognizable with a democratically elected government.
All 774 local governments in Nigeria will now receive their allocation directly from the Federation account. This is one of the highlights of the Supreme Court's judgment earlier today, granting financial autonomy to local governments. The court declared that giving preference to caretaker committees over democratically elected council is unconstitutional, and state governments deliberately shy away from conducting local government elections so they can control the councils. You will recall that the federal government instituted the suit against all the 36 states of the Federation, seeking an order preventing the governors from arbitrarily dissolving democratically elected councils and granting financial autonomy to local governments.
This is Supreme Court, and there is no room for appeal. As it stands today, every state governor in every state of the country needs to cease from conducting or inaugurating caretaker committees in local governments, and they should ensure that they conduct an election for local government. Well, they were not physically present, but they appeared through their various attorney generals, and the court made the order today, like effective today, and this order will be served on the various state governors and the House of Assembly. Although we know the State House of Assembly make their own laws in respect to local government, but the Supreme Court says and stands that the Constitution is supreme. And although they are making reference to Section 160 of the Constitution, that the Constitution did not allow that any tier of government is a subset of any other tier. We have the federal, the state, and the local government. So this local government should not be made to be a department of the state government or under the state government.
And former chairman of Karo local government of Nasarawa State, Akala Samuel, joins me on the news for more perspective to this judgment. Good to have you join us.
Thank you. It's my pleasure.
So let me start by asking you what you make of this judgment, and from your experience, what impact or actual impact it will have on local government administration.
Well, for me, it's heartwarming receiving this news this morning. Though I didn't expect anything less. As an ardent advocate of the freedom for local government, I am most excited this afternoon with this latest development from the Supreme Court. And for me, this is consistent with the yearnings of Nigerians. Mr. President has succeeded to put his name in the sands of history, and of course repositioning the country for development and fighting insecurity. For me, the impact, the positive impact of this development for me is endless, because the local government will now be able to discharge its responsibility as enshrined in the Constitution. I assure you that going forward, once funds begin to hit the account of 774 local government, it will enable council chairmen in various local government councils in the state to tackle issues of insecurity, tackle issues of development, and other sundry issues that have challenged the sovereignty of the country. So for me, I am excited, super excited as a Nigerian, and I'm sure majority of Nigerians are also excited about this development. I congratulate Mr. President, I congratulate the Attorney General of the Federation for taking that bold step to sort for the interpretation of this Constitution.
Let's talk about the impact that this will have, which is what I was asking earlier, because when you check most of the states, some of them are running caretaker committees right now, but for those who conduct elections, you realize that the ruling party usually would win all local government elections. And so what you have at the end of the day are local government chairmen who are loyal, very loyal to the governor. Does this sort of, does this change that level of transparency that would see, at the local government? Is there a way that the governors can still circumvent this particular judgment?
For now, the only way the governors may interfere in the affairs of local government. I am yet to get the details of the judgment as regards who henceforth will conduct local government elections into the 774 councils in Nigeria. But if the judgment still retains the state electoral body, that is the only platform the governors now have to decide who becomes local government. But I can assure you, even at that, the citizens will now be more well positioned to ensure that even if the governors are conducting elections, they will now come out heavily to elect officials of their choice and guard them and ensure that they emerge victorious. Now, as to the management of the finances, now it is entirely the business of the local government council chairman to ensure that they put their finances to proper use. If a chairman decides for whatsoever, remove funds from his account and take it and to the governor in the state, that is entirely his business, and he will have his day with the AFCC and ICPC, But of course, for states that are still running caretaker committee, today the judgment makes it explicitly clear where there are no democratically elected local government officials, funds for those local government will not be tempered by anybody, be it state government or agents of the state or agents of the local government. It means that those funds will not be disbursed. That is the implication. Those funds will not be disbursed to local government without democratically elected officials, because that is clearly Chapter 7, subsection 1 of the Constitution, clearly states that only a democratic system of government is guaranteed under the Constitution of the Federal Republic of Nigeria, 1999, as amended.
Well, I mean, I know that in a matter of moment, we'll see lawyers interpreting what all of this means. Thank you so much for your time. Former chairman of Karo local government of Nasarawa State, Akala Samuel.
Thank you. It's my pleasure.
Away from judicial matters, let's turn to other stories. The Federal Executive Council has announced a suspension of all memoranda requiring cost variation for projects undertaken by ministries, departments, and agencies. The meeting presided over by President Bola Tinubu also ordered for a new comprehensive review of the public.
Thanks for tuning in to Smart Okason TV show. Keep exploring, stay curious, and never stop getting the latest information happening around. Don't forget to like, comment, subscribe, and share to keep the intellect flowing. Until next time, keep sharpening and be smart.